Today we are taking a closer look at the common law. There are close to 200 nations existing in the world today. Each has its own identity, different political beliefs and ambitions, and each has its own legal system representing these differences. Thus, certain behaviour may be illegal in one country and be perfectly legal in another. For reasons of simplicity, the world's legal systems can be classified under three basic headings. The Romano-Germanic system of law, referred to as civil law, the Anglo-American system of law called common law, and fiqh, the Islamic jurisprudential system based on Sharia law. The importance of the common law is that it has a worldwide presence and is the legal system of choice for some of the world's largest and richest countries and companies. For example, the common law is the legal system in countries as diverse as the United States of America, with the partial exception of the state of Louisiana, England and Wales, Ireland, Canada, with the exception of Quebec, Australia, New Zealand, South Africa, Malaysia, Pakistan, Singapore, Hong Kong, and many other Commonwealth countries. Other countries, such as India, have taken the common law and mixed it with their own local laws. Although many countries apply a system based on the common law, referred to as common law countries, the specific character of the laws developed by each of these countries may vary greatly. However, despite this difference, all of these countries share the fundamental approach of the common law, namely a system founded on extensive judicial power and consequently the important role of case law. So what are the sources of law in the common law? The common law has a number of different sources: case law, legislation referred to as statute law, and other sources such as custom and canon law. Let's first take a closer look at case law. Unlike civil law, which is set out in a structured system of codes, common law is initially derived from case law. Under the case law methodology, certain decisions adopted by higher courts may be considered to set a precedent which must then be followed by all courts of equal or lower standing. This is called the doctrine of stare decisis. In this way, the content of the law is developed by way of a series of court decisions, referred to as case law. However, a court decision can run to hundreds of pages, and obviously not the whole decision will be considered binding on subsequent courts. Instead, it is only the rule of law or the principle established by the decision, referred to as the ratio decidendi, that binds subsequent courts. Sometimes, in a decision, a judge will also issue an opinion on a related matter, but not one coming within the actual facts of the case. Such opinions are called obiter dicta, and they are not considered to create a binding precedent. This is because a court is only empowered to rule in law on the actual facts of the case before it. However, although such opinions are not binding, they can be influential in subsequent cases, especially if issued by a leading judge. Effectively, with obiter dicta, a judge is giving his opinion on how he would have decided the case had the facts been different. The area of case law is further divided into two types of case law: common law case law and equity case law. First, we'll take a look at common law case law, which was developed by the King's Courts. Common law case law was developed from the decisions of the King's common law courts established from the 12th century onwards. However, the system of common law developed by these courts was procedurally very technical, and over time it lost touch with more fundamental notions of justice, such as right and wrong. Further, the common law courts only offered complainants one remedy, namely damages. As a result, the Chancellor, who who was the king's principal advisor and normally a member of the clergy, developed an alternative system of case law referred to as equity. Equity was developed not so much to compete with the king's common law, but as a discretionary remedy designed to complement the common law when it failed to provide a complainant with an appropriate solution. Equity was dispensed in its own separate court, referred to as the Court of Chancery. As it was developed to respond to problems with common law case law, equity from the beginning was only applied when the remedy provided by the common law was inappropriate, and this is still the case today. Thus, equity is said to be a discretionary remedy. Substantive areas of law developed by equity include trusts and succession law. Moreover, in place of the common law remedy of damages, equity developed remedies such as injunctions and specific performance to better answer the needs of complainants. However, the most important source of law in the common law is statute law, which takes precedence over both common law case law and equity case law. The first parliaments in modern England date from the 13th and 14th centuries, and since then the influence of Parliament has grown as the country has slowly become a democracy. Statute law is now the dominant source of law in the UK. Statute law is written law but should not be confused with civil law codes, which are normally more detailed. Traditionally, common law statutes tend to be broadly written, allowing the courts to retain large powers of interpretation. Along with case law and statute law, there are other sources of law such as custom and canon law. Custom becomes a source of law when an established pattern of behaviour becomes a right that may then be relied upon before the courts. For a custom such as a right of way to be considered law, it must have existed since time immemorial, i.e. since 1189. If this cannot be established, the custom must be shown to have existed as far back as living memory. If it is established that reliance on the custom was interrupted at some time between 1189 and the present, then the custom will not be accepted as a source of law. The custom that one wishes to have recognized as a right must be reasonable and also must not offend fundamental notions of right and wrong. Moreover, the scope of the custom must be definite and specific. For example, a vague claim to have a right of use over a certain area of land, which is not specific as to the exact location of the land and the nature of its use, will not be entertained by the courts. Finally, the right claimed under the heading of custom must have been exercised as of right, i.e., not exercised by way of stealth. There is also canon law, or the law of the Roman Catholic Church, which has been an important source of law and has helped to shape the common law, especially in the area of equity, which, as we have seen, was first developed by ecclesiastics. Generally, canon law concepts of right and wrong, the sanctity of marriage, and the special position of the family underlie many areas of law, making up the common law today. Now let's look at other sources of law that are specific to the common law UK system. After World War II, European countries decided that in place of nationalism that had led to two world wars, it was necessary to try and promote cooperation between them. As part of this process, the Council of Europe was established in 1949. Thereafter, the European Economic Community, or EEC, was created in 1957. This organisation is now called the European Union. First, let's take a look at the Council of Europe and the European Convention on Human Rights. The European Convention on Human Rights was drawn up by the Council of Europe in 1950 and entered into force in 1953. However, it did not become an integral part of UK law until the adoption of the 1998 Human Rights Act. Pursuant to this Act, the UK courts and the UK administrative bodies must now respect the provisions of the Convention when adopting decisions. The Convention has its own court, called the European Court of Human Rights, and its own administrative body. Under the Convention, if a UK citizen considers that the UK authorities have breached his or her human rights, he or she must first bring an action before the UK courts, and once their domestic remedies are exhausted, they may then bring an action before the Court of Human Rights located in Strasbourg. Now let's take a look at the European Union. The United Kingdom joined the European Economic Community in 1973. In 1992, the organisation expanded the scope of its activities and is now called the European Union, or the EU. The two most important types of EU law are regulations and directives. After adoption by the European Union, regulations apply directly in the Union's 28 member states and thus apply directly in the law of the United Kingdom. Directives, once adopted at European level, have to be implemented into the law of the member states and thus must be implemented into the law of the United Kingdom by way of an Act of Parliament. Since the decision of the European Court of Justice in Costa and NL, European Union law is considered to take precedence over the national law of the United Kingdom. We hope you enjoyed this quick look at the common law.